on Lagoon Radio. It's Friday, the 17th day of September 2021. And today we are talking about the effects of failing to registering land instruments in Nigeria. And our guest this morning is Barrister Gerard. Barrister Gerard Nabokwo. Barrister, good morning and welcome to the program.
Yeah, good morning. Thank you very much.
Yeah, I hope I got that your surname correctly.
Yes, Nam Okwo.
Okay, and yes, Barrister Gerard is the principal partner, Genius Attorneys. Yeah, and remember, at Know Your Rights, we educate you as a citizen to know your fundamental rights as a citizen of Nigeria. And remember, you can download the app on Google Play Store and Apple Store. You can also follow us on our social media platforms. On Facebook, we are live. Yes, we're transmitting live on Facebook, Lagoon Radio Nigeria, and on Instagram, Lagoonradio.Ng. Now, talking about the effects of failing to registering land instruments in Nigeria. Barrister, let me go this way. Must I, as an individual, register my land?
Thank you very much. The law is that once you buy a property, the law requires that you should proceed to the land registry to register your title documents. It's only when you have successfully registered it that it will be admissible in court of law to prove that indeed you are the owner of the said property.
Okay. Now, before we talk about the effects, what are the benefits of registering these properties?
Yeah, like I said earlier, once you register your property, what it has done is that it has automatically conferred a legal title on you. So you've become the real owner of the property. At any point in time that anybody wakes up and challenges your ownership of the property, you can always tender your documents and say, indeed, these are my title documents. I registered as the law required, and I, legitimately procured the property. And then secondly, when you register your title documents, another thing it does is that it constitutes notice to the whole world. If somebody else wants to acquire the property, of course, in Lagos, for instance, when somebody wants to buy a property, the person goes to the land registry to do a search, what we call a due diligence search. So, what registration does is that it constitutes a notice to the world, to the extent that whoever that sees that this person has acquired this property, the person would have to take some steps back. So that's it. And then thirdly, if you register your title document, it it gives you what we call priority over any other person who might want to register the same property behind you. If, for instance, Mr. A sold property to Mr. B, and then Mr. B did not register, and then eventually, by whatever means, Mr. C acquired the same property and goes behind to register it. So what it means that automatically the Mr. B has lost, his title. Okay, the only remedy he may have is probably to proceed against Mr. A to get his money back. So registration also confers priority over, who bought first and all that.
Mm. Okay, having said all this, now where can I register? Where can I register my land?
Yes, the law provides that in every state there is the lands registrar, and then who is in charge of registration of title documents. And the office of the lands registrar is at the lands registry. In Lagos State, for instance, we have the lands registry at Alausa. If you want to register your title documents, you proceed to Alausa to register your title documents.
Okay, is it only at that place? Where do the position of a lawyer in registering a land comes in?
Yes, a lawyer is an expert, and being an expert, like Lord Denning rightly said, that God forbid that a lawyer would know all the laws, but at least should know where to find the law. So if you consult a lawyer to register your land for you, of course, there is what we call a perfection of title. When you once you procure a property, you are going to do what we call perfection of title, which includes um, getting the governor's consent as provided by Section 22 of the Land Use Act. After you have gotten your governor's consent, you proceed to for stamping. That is the second step in perfection of title. You proceed to stamp. The law says you must stamp within 40 days of executing your title documents. After that, then you proceed to the land registry for registration. Okay. So the Lands Instrument Registration Law of Lagos State, for instance, provides that you ought to register within 60 days of the execution of the title documents. So I think that's where the job of a lawyer comes in, because he knows the procedures involved in doing all these whole transactions.
Okay, now, well, you mentioned something about the Land Use Act.
Okay.
Now, what does the Land Use Act really say? Because over time, I've heard the Land Use Act, but being a layman, as a lawyer, you can tell us better. What does the Land Use Act say, simply?
Yes. In relation to registration of title documents, the Land Use Act, pursuant to Section 48, provides that every state shall have its own land use registration law, land registration law, and this state land registration law could be modified, the way it suits the state, as long as it conforms with the provisions of the Land Use Act. Now, in Lagos State, for instance, we have the Land Instrument Registration Law of 2015, which in Section 26 provides that after the execution of title document within 60 days, you ought to proceed to register your title documents.
Okay, you're still listening to our legal program, Know Your Rights, on Lagoon Radio, and we are talking about the effect of failing to registering land instruments in Nigeria, and you're hearing the voice of Barrister Gerard. We'll go on this short break. When we come back, we look at what it is, the certificate of occupancy, and the role the governors play in the Land Use Act. Keep listening to us. We'll be right back after this break. Okay, you're welcome back. It's still Know Your Right, our legal program on Lagoon Radio, your number one online gospel radio in Nigeria and the official radio of the Anglican Communion Diocese of Lagos. Remember, you can download the app on Google Play Store and Apple Store. You can also follow us on our social media platforms on Facebook, Lagoon Radio Nigeria. Of course, we are live. And on Instagram, Lagoonradio.Ng. Yes, listen to us directly via the link, www.lagoonradio.ng. And we are talking about the effects of failing to register registering instruments in Nigeria. Barrister Gerard Wamoko is here. He's the principal partner at Genius Attorneys. And Barrister, having said all this, in the intro, now looking at that Land Use Act, from my own observation and from the explanation I got earlier, he said that is an act that all lands are vested in a state governor. The state government controls the land on its territory. Is that the right definition to that?
Yes. Thank you so much. The Land Use Act, pursuant to Section 1 of the Act, provides that all lands within the state are vested on the governor of the state, who shall hold it in trust for the use of the whole citizens within that state. So, indeed, you are right to say that the governor is vested with the powers to control all lands within the states.
Okay, looking at that act now, now we have the certificate of ownership. Now, before we get to that, but what happens when a land is already registered and maybe I decided to buy a new land. Now I bought the land, but it has already been registered. Am I going to perfect another registration?
You know, as the law says, that before you alienate your interest in a particular land, you must first seek and obtain the consent of the governor.
Okay.
That's the provisions of Section 22 of the Land Use Act.
Mm.
So now, when somebody else had sought and obtained the consent of the governor and has registered, and he wants to, sell to another person or alienate his interest to another person, they also have to, in order for him to vest the interest in another person, he has to also seek and obtain the governor's consent, and then of which a new certificate of occupancy would be given to the new person. Okay, because the old person is not going to give the certificate of occupancy in his name to the person he's selling to. So it's your duty, to ensure that the certificate of occupancy you have, is in your name, so that you will be able to transfer to another person whenever you want to sell. Okay.
Okay, I haven't heard of certificate of occupancy.
Okay.
But sometimes it seems as if it is hard to own that certificate of occupancy in Nigeria because it varies depending on the state governors.
Well, of course, the bureaucratic bottlenecks we have in Nigeria. It's not as if the law says it should take a long time per se. It's just the procedures it has to take for you to get that, and that's why you need to involve a lawyer, because, like I said, a lawyer who is an expert in the field knows how best to go about it to ensure that it comes out as quickly as possible. However, the law also says that when parties want to sell, they can actually proceed to sell, and after the sale they can also apply for the consent of the governor in view of the fact that it takes time to come out. So if Mr. A wants to sell to Mr. B, for instance, they can proceed to execute the deed of assignment. Mr. B can transfer the money, the purchase price, to Mr. A. Then they can, at that point, what the law says, the interest is inchoate. Inchoate in the sense that there is still something that needs to be done. Okay, so it's not as if the title is invalid, but it's inchoate. Inchoate means that there is still something that needs to be done, which is that obtaining governor's consent and then the C of O and all that.
And a lot of times, I've heard that maybe a governor comes on board and he revokes the licenses, maybe the certificate of occupancy. He revokes every certificate and wants to start afresh. Legally speaking, is that a right thing to do?
Well, the law says, like I said earlier, that all lands within the state are vested on the governor, who holds it in trust for all the citizens in the state. So, the pursuant to Section 28 of the Land Use Act, it says that the governor can actually revoke statutory right of occupancy, okay, for public purposes. So the Section 29 provides that, when the governor revokes, the person, the owner of the property, is entitled to a compensation to the tune of whatever investment he had made on the land. So if, for instance, the governor of Lagos State wants to establish a public hospital, okay, which would be rendering medical services to the people of Lagos State at a very cheap price. The governor can actually revoke someone's right of occupancy, okay, and it could be used for the hospital. However, if the person had made any improvement on the land prior to the revocation of the statutory right of occupancy, the governor or the state government, um, so to speak, would make adequate compensation to the person. So an assessment will be conducted to know how much this person, whatever the property, whatever the improvement person had made, is worth, so that adequate compensation would be made to the person. Then, in addition to that, where the governor revokes for a purpose that is not a public, that is not in the public interest, the person, the owner of the property, can actually challenge it in the court of law, and such revocation can be held null and void.
Okay. Okay. Before we delve into the judicial process first, let's look at the effects of failing to register a land properly. What are the effects?
Okay. So, when one executes deed of assignment, for instance, or deed of sublease, or deed of legal mortgage, when you fail to register, what has happened is that um, you do not have the legal title over the property. Okay, so you don't have the legal title. However, you have obtained what we call equitable interest over the property, and the equitable interest could be defeated if somebody else buys the same property and registers before you. Okay, so if Mr. A, for instance, sells the property to Mr. B, and then Mr. B fails to register, and eventually something happens, and by one way or the other, Mr. C acquires the same property and goes ahead to register before Mr. B. What this entails is that Mr. B has lost his interest in the property. So the effect of failing to register is so much that any prudent buyer would not want to try it. Okay. So secondly, like I explained earlier, when you, for instance, in deed of legal mortgage, if somebody has a property in Lekki for his ones, for instance, and the property is worth 300 million, and he used the same property to collect a loan from a bank, and the deed of legal mortgage was executed, the bank is supposed to register it. Okay, so one of the reasons why the bank has to register it is just in case that fellow wants to sell it behind the bank. Okay, if for instance the property is worth 300 million and the person used the property to collect a loan of 100 million, and the bank or whoever that gave the loan to him did not register the deed of legal mortgage, what has happened is that the person has failed to notify the world that I have interest in this property. Okay, so it will not constitute notice to the world that there is another interest on the property. Okay, So then thirdly, like I said, registration, priority governs registration. So if Mr. B bought a property from Mr. A and he fails to register, let's say for instance on 3rd of March, Mr. C presented the same document, the 30 document at Alausa, for instance, for registration. And then on March 3rd, on March 4th, they commenced registration. And then probably around May, Mr. B, who bought first, now brought his document and said, oh, I bought this property from this Mr. A. I want to register it. They'll tell him, sorry, somebody else had, bought this property, has commenced registration and all that. And, invariably, you would have to probably face another battle, be able to come out of it. So,
okay, I have one reaction.
okay.
Somebody said, please, barrister, I don't understand what you mean by deed of assignment. Please explain briefly. What's the deed of assignment?
Okay. So when you buy a property from somebody, okay, so once you pay the purchase price, what both of you, there's a document where the lawyer says, oh, Mr. B bought so property from Mr. A. Okay, he states the amount paid, the date it was paid. He narrates how Mr. A got the property and everything. So that document containing that agreement between Mr. A and Mr. B, saying that Mr. B bought this property from Mr. A, is called deed of assignment.
Okay, that's just it.
Yes.
Now, another one. Okay, one of our listeners says, please, this has been our family problem. We have a land, and our CFO was revoked by the governor. We've been on this case since over 6 years, and nothing positive has come out of it.
Okay.
So he's asking your advice as a lawyer. What are they to do? That their CFO was revoked by a sitting governor, and they've been on this case for 6 years and no breakthrough.
Okay. So where the CFO was revoked, they have to find out on what basis was it revoked. First and foremost, they have to get a lawyer, okay? Because sometimes what constitutes a public purpose is open to interpretation. Okay, like I said initially, that where, for instance, the governor has revoked someone's interest in land for the use of a hospital, for instance, for building a hospital, for instance, it's open to interpretation. Does this fall within the category of public purpose? Okay, so they have to consult a lawyer who would need to inquire as to why the governor revoked their statutory right of occupancy. Okay, is it for a public purpose? And if indeed it is for a public purpose, have they been compensated? Have they been paid any money or whatever compensation that they deserve? Okay, have they been paid? If they have not been paid, have they gone to court, to institute an action to claim so? Or have they written to the government even? Okay, so if they say they have been on this case for 6 years, is it like they have gone to court?
Yes, in court process.
Okay.
For the 6 years.
The matter has been in court.
Yes.
For the past 6 years. Well, I think they need to probably exercise some patience. Okay, because of course you know how our system is. It's not that fast in terms of our the judicial system, the whole adjournments and all that. So I believe that the court is in the best position to, give a ruling as to whether appropriate or not the revocation is. So I just think they should give it some time.
Okay. You're still listening to Know Your Right, our legal program on Lagoon Radio, your number one online gospel radio in Nigeria and the official radio of the Anglican Diocese of Lagos. We've been talking about the effects of failing to registering land instruments in Nigeria. And you've been hearing the voice of Barrister Gerard. We'll go on this short break again. When we come back, we'll look at the role of the judiciary, what you have to do, even before buying the land. Do you need a lawyer? That's what we consider when we come back. Keep listening to us. We'll be right back. Okay, you're welcome back, and we've been talking about the effects of failing to registering land instruments in Nigeria. Remember, you can download the app on Google Play Store and Apple Store. You can also follow us on our social media platforms. On Facebook, we are live. Yes, Lagoon Radio Nigeria, and on Instagram, Lagoonradio.Ng. Barrister, let's look at the role of judiciary. You are a legal practitioner, and most times, if anything happens, you people will say you need a lawyer. In this case, do I need a lawyer before buying a land?
Thank you so much. Now, before you buy your land, if you don't want to buy trouble for yourself, because somehow the real estate industry is a lucrative area, and then because of that, there are a whole lot of people who are into the profession, So some could sell properties that they actually don't own, and this whole thing could land them, in court for a very long period. So if you want to buy a property, whether land or house or whatever, you need a lawyer who would conduct what we call due diligence search for you. To ensure that the land in question is not under any encumbrance. So, like I mentioned earlier, a land could be under legal mortgage. For instance, somebody had used a property to acquire a mortgage, a loan, okay? So, and then the person wants to sell the same property to you without discharging the loan. Of course, when you buy such a property, the bank or whoever that gave him the loan would come after you. Then another thing is somebody could also want to sell a family property to you when he has not obtained the consent of the rest of the family members. The law says when you want to sell a family property, you need the consent of the family representatives. So that somebody doesn't wake up tomorrow and say, "Oh, I wasn't aware that this our family land of our family house has been sold," and the matter would land in court. So you need to do thorough search. Then another thing is a property could also be under what we call charge. So you equally need to also do another search at CAC as well. You understand? So it could be that a certain charge was placed on a property. Okay. So you need a lot of search, a lot of due diligence search, before you can pay for any property. Otherwise, you would land in court, and the whole purpose of buying that property will be defeated. The matter could last 5, 7, 10 years in court. You can imagine a property you bought for 1 billion naira, for instance, that you want to use to build a company, and you are in court for 10 years, the whole essence of paying for the property has been defeated. And then you are not even sure that you are going to win the case at the end of the day. So you need a lawyer actually. You need a lawyer.
Okay, and talking about needing a lawyer, like we just read from the reactions of our one of our listeners
Okay.
that said that they've been in this for 6 years.
Okay.
Now, this is judiciary.
Okay.
Sometimes, when there are times like when reconstruction is going on in some areas, and you see some of these people who have these registered properties not being compensated, what do they do? Do they still need a lawyer even when the government knows what to do at the right time?
Sorry,
So,
come again.
like some people who their properties are being demolished during reconstruction, and a lot of them do complain that they didn't get any compensation from the government. Where does the lawyer come in this case now?
Well, there are some areas where people are prohibited from building.
Okay.
So, if for instance you are building in a place that is very close to the express, maybe you are building a shop or a house or something, and then probably when you are starting, you were warned not to. You understand? So, of course, like I told you, that the governor controls the whole land within the state. So, if the property was originally built in a forbidden area, of course, it will be demolished without anything. But if it's a place where maybe there wasn't an existing road and maybe the government wants to create a new road on that particular place, okay, then your house was one of the houses, your shop or something was one of the properties that were demolished. Of course, you're entitled to adequate compensation from the government. And then just to add, when I was advising our friend who asked my advice on the matter in court, ordinarily when a matter is in court, you don't really discuss it. But then my advice is, another advice to them is that, they should also try as much as possible to see if they could settle out of court. Because sometimes everything doesn't necessarily need to go to court. Sometimes it could be that the government had probably made certain offer to them which they have not taken.
Okay.
So if the government has made certain offer to them, they should consider it. If the government has not made, let them write to the government. Okay, they could write to them. They could just find a way to settle the matter out of court. Because at the end of the day, you might gain or you might lose. Do you understand? There is no. It's not cast on stone. So for me, sometimes when I look at certain cases, I would advise my client properly. If it's a case that I know this person is going to spend so much battling in court, and at the end of the day, nothing serious is going to come out of it, and probably there's an offer on the table, to settle out of court, I will tell you, collect it. Then if you except if you insist, or where the offer is unreasonable, very ridiculous, then we can say, okay, let's battle it in court. But if the defendant has made a reasonable offer, you can collect it and move on.
Okay. Finally, as a legal practitioner, what do you advise Nigerians, even before buying a land or when you get the land as a legal practitioner, in order to avoid problems? What do you advise?
Well, for me, I have always, advised those who are interested in acquiring properties, to be as much as possible, be diligent. Okay. If you want to acquire a property and you don't have the money to perfect your title and do the relevant things, you can leave it, pending when you're able to get the whole money. First and foremost, as at the time you have made up your mind you want to acquire a property, you should involve a lawyer. Let the lawyer advise you. Okay. Let the lawyer do search on the title of the property. When the title is okay, the title is fine, and the lawyer has said, okay, you can proceed. Now, the lawyer will also do the deed of assignment. And when the lawyer is done with the deed of assignment, and you have paid him whatever percentage that you guys have agreed, then the lawyer should also advise the client that he should proceed to perfect his title, as we have discussed here, which includes obtaining governor's consent, stamping, and registration. So when you have done all these, you know that you have peace of mind. You understand? There's nobody that can challenge your title over the property, except where the government wants to take it for public purpose, which you would be adequately compensated.
Yes. And sometimes when we have these court cases on land issues, why does it linger?
You know, like the law provides, they said he who asserts must prove.
Okay.
Okay, so the Evidence Act, by pursuant to Section 131 of the Evidence Act, says he who asserts must prove. So if you say you are the owner of a property, for instance, that is in dispute, you must prove your ownership of the land, which is even why the law says it has to be at the High Court. Okay, for instance, you want to evict tenants from your property, you can go to magistrate court. But once the issue of ownership is involved, it has to be at the High Court. And reason being that you need to prove that indeed you are the owner of this property. Now, by the Supreme Court's decision in the case of Dundu and Okumagba, there are some procedures, some methods of proving ownership to land. Okay, one of which is providing your title documents. Okay, by calling witnesses as well, those who probably know that you're owner of the land and all that. And these whole things take time. For instance, an owner of a property may have like 5 to 10 witnesses he wants to call to court. You understand? The other person who is opposing him might also have numerous other people to call. You understand? So this whole thing take time. And sometimes the defendant, who probably knows, okay, this person is the owner of this property, but I don't want to leave it for him, intentionally may want to delay the case. Be asking the court for adjournments, and sometimes, you see that litigants could actually pursue a matter from High Court to the Supreme Court, maybe on a particular issue, and still come back again to the High Court. Maybe the High Court gave a ruling on a particular issue. Do you understand? The lawyer to the defendant may say, okay, we don't agree on this, we are going on appeal. They go to the Court of Appeal, from Court of Appeal to the Supreme Court, and then eventually the Supreme Court gives final ruling on that particular issue, just one issue. Do you understand? They would come back again. So you can imagine how long it will take. That's why I always advise that whenever you want to acquire a property, seek the services of a lawyer, an expert in real estate. He will guide you accordingly.
Okay, you've heard this morning that you need a lawyer. If you want to acquire a property, you need a lawyer. And that's the size of the package this morning on our program, Know Your Rights. Thank you, Barrister Gerard, for coming on the program.
Thank you so much.
We hope to see you when next we call on you.
Definitely.
Okay. This is where we draw the curtains on the program. And big thanks to our producer, Olumakaiye, for pressing the right buttons. And we'll be back again next Friday by 9:10 a.m. Keep listening to Lagoon Radio, your number one online gospel radio in Nigeria. And enjoy all our programs. Do have a lovely day.